In this presentation, we're going to talk about records of interview. What is a record of interview? A record of interview is a recorded interview. It might include a video recording, as in the case of serious police matters. It may be digitally recorded, or it may even be a written record of each individual question asked by the interviewer and the interviewee's response to that question. So in simple terms, the format of a record of interview is the single question asked and then the answer. It can be recorded, videotaped, or written. The record of interview should be a true, accurate, and fair representation of the conversation that's had between the interviewer and the interviewee. It should detail all the relevant information relating to the circumstances of how that conversation was conducted. The record of interview should also reflect procedural fairness. In anything that you do with a record of interview, you have to reflect openness, fairness, and transparency. The use of a record of interview is to speak with any person reasonably suspected of being involved in a breach of legislation or policy, and where it is reasonably likely that proceedings, whether they're disciplinary or otherwise, may be instigated as a result. More importantly, when we refer back to the elements of the offence and the mental or the fault element, such as intention, recklessness, knowledge, or negligence, where an oral confession is the likely outcome, that oral confession must be protected within the way that you conduct your record of interview. You've got to protect the evidential outcomes. You must protect the integrity of those outcomes established by the interview, i.e., that confession. The reason why it is so important to protect the confession is a confession is one of the exceptions to the hearsay rule, and it's admissible hearsay. So if the interview was conducted in such a way that there was force or pressure or some sort of unfair action placed on the suspect, that confession will be dismissed and you may lose a prosecution because that element may not be able to be proved in court. The record of interview must amount to a true, accurate and fair representation of that conversation and how the interview has been conducted. The following guidelines are important issues that should be addressed during a record of interview. They are given as a guide, however, you must follow your organisation's policy, procedure and or legal advice that's established within that organisation. Generally, the legal advice in regards to the way an interview should be conducted will be based on previous interviews, previous matters and previous outcomes. At the start of the interview, you will have an introduction and preamble, or an opening administration as some people refer to it as. The introduction and preamble is used to explain where and when the record of interview is being conducted, who you are, who else is present, and what time the interview commenced. After that, you will go into the issue of voice identification, where there's no video camera and it's just an audio, digitally recorded audio file. After the introduction and preamble, it is now necessary to identify the voices of who the interviewee is, any other persons present, whether you have a corroborator or second interviewer. You may have a support person, you may have an interview friend, you may have a lawyer, you may have a union representative. You need to also clarify that there are no other persons present in the room during the interview. One of the most important things that you need to look at, which often is overlooked by government departments, is addressing the issue of custody. Interviews should be undertaken voluntarily by the interviewee. You can't make someone participate in an interview unless you have a statutory modification to the common law right of silence, which may be what's called compulsive powers. You may have legislation, the enabling legislation that's administered by your government department may have compulsive powers where you can direct someone to come into the office or your office, answer questions and provide documents. There is still no compulsion for them to sit in that interview. They may commit an offence by not doing that, but they're not under arrest and they need to have that explained to them. It's vitally important to ensure that the interviewer understands that he or she is prepared to participate in the interview of their own free will and they are not under arrest and they can leave at any time if they wish. Or, as I said, if you have enabling legislation that directs people to attend and answer questions, that compulsive power must be explained to the person. However, they are still not under arrest and they are free to leave if they wish. You need to explain the fact that if they don't participate in the interview, there will be consequences and they may commit offences, but they are still not under arrest. Explain the interview and the process to them. The interviewee has the right to know why he or she is being interviewed and what the allegation is. This is procedural fairness. You need to explain to the interviewee the way in which the interview will be conducted. The fact that you're going to ask questions and invite them to provide answers to those questions. It's necessary to explain how to answer the questions and what to do if the interview doesn't understand something. Get them to ask you to clarify things if they're not sure. Also advise the interviewee that they can take a break if they wish. There is nothing wrong with taking a break. It shows fairness and it shows that the interview is being conducted in a reasonable manner. The interview must be voluntary. For the record of interview to be admissible in court and or admit that confession that was obtained, it's necessary to establish that the interviewee attended voluntarily and that no threat, promise or inducement was made by any person. Have the interviewee clarify these issues. One of the issues that you need to look at is the common law right to silence. A suspect does not have to self-incriminate or provide evidence against themselves in any matter. It's a common law right to silence that was established over 100 years ago by the UK legal system and the judges' rules in respect to establishing fairness. The interviewee must be warned that, and they need to understand that they have a right to silence and that they are not obliged to incriminate themselves. You must confirm that they understand this. This allows the confessions that are obtained to be admissible as evidence. As I said, a confession is admissible hearsay, and in order to get that hearsay into court, it needs to be shown that the person understood that they didn't have to talk to you if they didn't want to, and they knew the consequences of talking to you and answering questions and admitting to what they've done if they choose to. Sometimes there will be other rights that will be explained to the interviewee or the suspect. An interviewee is entitled to communicate or attempt to communicate with a friend or relative to let them know where they are and their whereabouts and what they're involved in. An interviewee is also entitled to communicate or attempt to communicate with a legal practitioner of their choice and arrange for the legal practitioner to be present during their interview to protect their legal rights. An interviewee is entitled to arrange for a support person to be present during the interview. There is nothing wrong with the interviewee having a support person present during the interview. It shows fairness and reflects fairness. If the interview wishes to have someone present, confirm that prior to the interview, confirm that they are able to speak to a friend, relative, lawyer by themselves out of your hearing, so they could have a private conversation with the person and explain what was going to happen. Also confirm that they're happy to have the friend, relative or lawyer present during the interview. Sometimes you will be asking questions about particularly sensitive or embarrassing issues that you need to explain to the person to say that we may be talking about something that may be sensitive or embarrassing. Are you happy to have that friend, relative or lawyer present while you do that? Very important issue. When you have an additional person present during the interview, you need to explain the role of the person prior to commencing the interview and set the ground rules. A solicitor or any other person present is there to support and help the person during their interview. They're not there to answer questions on behalf of the interviewee. After the interview commences, have the person explain to you what their understanding is of their role during the interview and clarify this if necessary. With Aboriginal or Torres Strait Islander people, ATSI people, there is a procedure called Anunga Guidelines. Anunga Guidelines are case law that has come out of Western Australia, Northern Territory, and it's to protect the rights of people who have limited education and limited intellect in respect to the process of being interviewed about something serious. Explain the caution and the right to silence. Question them to ensure that they understand. The interviewee has the right to have what's called an interview friend present during the interview, and generally in remote Aboriginal communities and places such as that, the interviewee is allowed to have an interview friend, and that interview friend will usually be a legal representative or someone who's in standing in the community, such as an elder in the community, to be present to assist them during the interview. In more urban or suburban areas or capital cities, it is just a simple matter of contacting Aboriginal legal aid, who will arrange for someone to be present during the interview. You must also establish the interviewee's level of education and understanding of the process. If you have any questions in regards to the fact that they may not understand fully what the situation is, be prepared to ask some questions, be prepared to suspend the interview, and be prepared to get someone to help them. When people have limited intellect or education, they are classified as a vulnerable person, and any information you get from a vulnerable person without showing fairness, any information that you get will not be admissible in court. If you feel that the interviewee is at a disadvantage, you must make arrangements for a support person to be present. And a person with impaired capacity cannot be interviewed without a carer present, and a child cannot be interviewed without a parent or guardian present. If you have any question or any concerns about the interviewee's ability to understand the English language, ask some questions to clarify whether the interviewee is capable of effectively communicating in the English language, and if there's a doubt, engage a qualified interpreter. All government departments have arrangements with accredited interpreters, and it's just a matter of contacting them and getting them to come down while the interview is conducted. If the interviewee doesn't want an interpreter, ask some questions and have the interviewee clarify this during the interview. You must also make sure that the interviewee is ready and able to be interviewed. You should confirm the interviewee's ability and fitness to be interviewed. Clarify these issues, such as if they've got any injury, illness or medical condition that may prevent them from participating in the interview appropriately. Clarify if you have any concerns whether they're on medication, drugs or alcohol. You must also look at the fact of whether they're sufficiently rested. If you have concerns, ask them questions about it. Also ask them the general question, is there anything else that may affect the interviewee's ability to be interviewed? Sometimes when you go and interview someone in a record of interview, a formal record of interview, you may have had previous conversations with the person outside of that interview room. You may have digital voice recordings of those conversations. You may have field recordings, notes, and other documents that you've obtained during those conversations that you've had outside the interview room. These need to be adopted during the formal record of interview. This should be done after administering a fresh caution. It makes those previous conversations, notes and field recordings admissible in court, and it allows the interviewee the opportunity to comment on those notes and field recordings. This reflects natural justice and procedural fairness. If you're going to introduce any other material, statement, evidence, documents or exhibits, introduce the item again if it's something that's going to be damning to the actual case. I usually administer a fresh caution and say that I'm now going to show you some documents. Before I do so, you're not obliged to say anything unless you wish to. Do you understand that? Yes. And then show them the document or the exhibit. The introduction of evidence and exhibits often results in confessions and admissions being made. So administering a fresh caution is important to allow those confessions to be admitted as evidence later on, because you're reconfirming the fact that the person doesn't have to self-incriminate. Sometimes you'll have an interviewee or a suspect who will refuse to answer questions. Attempt to ascertain the interviewee's reason why they refuse to answer questions. Sometimes the interviewee will refuse to answer questions part way through an interview. Clarify whether this is a result of the particular question or the further questions or the line of questioning, or it is the fact that they've decided not to answer anything further. Advise them that this is their opportunity to provide their version of events. However, I have heard recently that even saying this is a form of putting pressure on someone. So again, look at the advice given by your legal advisors to your organisation. If the interviewee later agrees to be questioned after they've refused, ask them why they've now decided to answer the questions. Ask them questions whether someone has told them to answer questions now where they previously refused. If you're going to suspend an interview, it's necessary to explain the reason for the suspension of the interview and have the interviewee confirm the time of the suspension. When you recommence the interview, you must formally recommence the interview again. Have the interviewee confirm the time that the interview recommenced. Also clarify that no conversation about the matter was had during that break. Have the interviewee confirm in their own words what occurred during the break. Advise the interviewee that you're going to ask them further questions, and again, administer a fresh caution. When you conclude the interview, it's important to ask if there's anything that the interviewee wishes to add or clarify. Confirm that the interviewee was attending and participating in the interview voluntarily and of their own free will. Confirm that there was no threat, promise or inducement made to them to answer questions. Ask if the interviewee was satisfied with the way that the interview was conducted. If there's other people present, ask them if they have anything that they wish to say. And finally, you confirm the time that the interview concluded. In summary, you must ensure that your record amounts to a true and fair representation of the conversation and the circumstances of how that interview was conducted. You need to protect the confession that you obtain during that record of interview and ensure that the record of interview is admissible. You must show that you have followed the principles of procedural fairness and natural justice.